And Mr. Hurley, what's the state's position regarding bail?
The state would not object to a signature bond on the condition that Mr. Terrell follow all Wisconsin administrative rules, administrative code rules, excuse me.
Mr. Tobin?
Your Honor, I've never heard the entire administrative code proposed as a condition of bond, and I understand there can be good faith issues. Actually, having worked in a capacity of promulgating administrative rules and having seen individuals wearing robes and on benches even find that those rules are invalid, and the agency legal counsel being called into play. So I would ask that that be amended to state statutes, which are easier to have that interpretation.
Well, there is a statutory condition of bail in every case that somebody did not commit a criminal offense.
I think that would cover what Mr. Hurley's getting at.
Well, the other issue I have when I review this complaint is I do make a practice of determining whether there's probable cause. Maybe I'm missing something, but I'm not sure that I see probable cause in this complaint. The complaint alleges that he violated a condition of bail specifically to follow all Wisconsin administrative code rules. And then I think what's alleged is that he engaged in videotaping in the assembly gallery in violation of the rules of the assembly. Aren't the assembly rules different than the administrative code?
As Attorney Tobin said, the administrative code is deep and wide-ranging. There is no doubt about that. Whether the assembly rules are contained within the Wisconsin administrative codes, I do not know.
Well, I don't pretend to be an expert in administrative rulemaking or in the rules of the legislature, but I do think there's a difference between the two. The administrative code is, not to be redundant, is a series of administrative regulations that are promulgated pursuant to a process, and they have the effect of the rule of law due to the delegation from the legislature to the administrative agencies. I think they're distinguishable in fairly significant ways from the assembly rules, which govern conduct of individuals in the gallery and in the areas that fall within the jurisdiction of that house, as well as to the conduct of their members. I think they're two different things, and I don't think a violation of the assembly rules or the rules of the gallery on its face constitutes a violation of the administrative code. I don't think this criminal complaint adequately sets out a violation of the administrative code. There isn't a citation to some provision of the administrative code that would be violated by the conduct that's alleged in this complaint. What it alleges is that he is on bail, there's a condition of bail to obey the administrative code, and it alleges that he violated a rule of the assembly. And I think there's a, to use the connect the dots analogy, I think there's a failure to connect the dots in at least one respect. So I'm going to grant the defendant's motion to dismiss. I'll dismiss this complaint that is by definition without prejudice, meaning that the state is free to refile it if they can produce a criminal complaint that more accurately or adequately sets forth probable cause of legal action.
State of Wisconsin versus TV.
Normally I'd ask to turn to bail, though we had an earlier hearing involving Mr. Terrell where we had some discussion about the sufficiency of the criminal complaint. But you're not sure that I see a meaningful difference between this complaint and the Terrell complaint, but we should probably make at least a complete record on that point in this case because it is called sensitive.
At most, there's an allegation she was given a slip of paper purporting to set forth some internal rules of the one of the branches of the legislature without any allegation that they are in part that they are made part of the administrative code, let alone that she would have been at the time that she took whatever action or failure to act or omission, that she would have been intentionally in violation of any administrative code rules. So therefore, I would ask that this complaint be dismissed, and as precedent, state v. Terrell, 11 C up 2 seconds. We call the court's attention.
I seem to recall the case.
It's a 2011 case.
Though it's from about the lowest court of the land, so the reason I think the complaint fails to set forth probable cause, and I'll order that it be dismissed. That is without prejudice. That means, Ms. Lee, that if the state wishes, they're free to file a new criminal complaint, and if it sets forth probable cause to believe that a crime was committed, of course they'd be allowed to go forward on that complaint. My determination is that they haven't done that at this point. Good luck.
There might be right? The court may say the gallery rules aren't administrative code. They're also not state statute. Therefore, they are not a crime. However, the state can still bring forward a criminal complaint. So if they had brought forward some kind of civil charge, okay, but you can't hold somebody in jail on a civil charge. You just give them another ticket or something.
Okay, my name is Jim Miller. I'm an attorney, and I was in the audience here at a bond hearing held for T. Lee and Christopher Terrell. They had been put in jail when they were filming, videoing action in the assembly chambers. The reason they were jailed is that they had done this previously, and the conditions of their bail was that they should not violate any administrative rules. The judge that heard their case a little while ago dismissed the bail jumping charges against them, and they will be freed in a little while. The bail jumping charge was dismissed because the judge found that they might have violated an assembly rule, but in the complaint there was not a connection between assembly rules and administrative rules. So he found that the complaint was deficient, and he dismissed the case without prejudice, which means the state could possibly file the charges again. But for right now, Christopher Terrell and T. Lee are going to be walking free from the Dane County Jail in a little while, and we're here to greet them when they come out.
There's like 5 dudes getting released at the same time right now, but I just saw her.
By the way, sir, codes have to do with rights.
So maybe he should put it on.
I'm just,
because now you have rights.
I'm just suggesting that maybe.
Back.
You need a smoke, CJ?
No, sir. I'm clean now.
3 days in the clink, did they?
Hold on, I will start hugging. The van is under. I tried to call him.
I know, it routed it through Texas, and I was like, is this the IRS calling me?
Officer Davis, is that the new
Free the higher melanin too. That might be the best side of the movement so far. There's been some doozies. That is classy. I was shooting around your fan. So what exactly? Oh, I would have saved. I had like a bunch of cookies and stuff left, but I was like, ah, she's probably gonna be sick. I was like, she's probably gonna be sick of those.
I brought souvenirs.
They give you guys vanilla? I will never betray my badge, my integrity, my character, or the public trust. I will always have the courage to hold myself and others accountable for our actions. I will always uphold the Constitution, my community,
And the agency I serve.
and the agency I serve.
Law enforcement. Oath of honor.
Oath of honor. Oh, there he is. Hey, you should read statutes before you try to take away days of my life. Good try, though. I'll be back.
And keep your damn hands to yourself.
Yeah, and don't ever touch her again. All right, very quickly, turn to number 9. Number 9 is, have you been to jail for justice? Now, we have to serenade them back to jail for justice. Let them eat, but let's belt this out for them with a little extra energy. And this is true. We don't have time to go into the story right now, but this is unbelievable. And sung the song for freedom, or marched that picket line. Have you been to jail for justice, then you're a friend of mine. I got out of jail. We got out for because the court commissioner determined that breaking assembly rules does not constitute a crime or breaking of administrative code.
Hey.
And so they dismissed the case against us for bail jumping, and we were released. However, we have another case against us for filming in which we have until today to turn ourselves in.
No, I'm not.
So we have like a couple of minutes here before we're going right back in the jail.
So
you're going back to jail?
Yep. We're going back to jail for September 13th.
Filming in the gallery again. Same thing.
Yep, same thing.
Day.
So the signature bond says either sign it or the sheriff can detain you until you do one of three things. So they're going to not do those three things and sit and wait. Well, that's because
we can't turn ourselves in because there's no warrant for us right now. So here's T's, but I have one that says the exact same thing. And it gives us 10 days to sign that or turn ourselves in. I've never been so happy and then so angry right away. Yes, I'm free. Are you effing kidding me? I have to go back. I'm still wearing the same boxers I was wearing last time I got. Okay.
I changed.
Yeah.
For the record, I changed.
I'm not.
So she doesn't do anything right now. We can't just turn ourselves in without a warrant.
Oh, you can turn yourself in without a warrant.
Well, but the thing is,
there's gonna be a warrant.
okay.
Our interpretation of the bond is that the sheriff will detain you if you don't do it.
That's your interpretation.
Right, so that's why we're here, so we're just trying to figure out what we should do instead.
I just got out of BS charge of bail jump. I'm not trying to bail jump on this.
Yeah.
You're not trying to, but you are because you're not signing it. So when they're going to issue, what they're going to do is your attorney is going to file a motion, like he said, file a motion with the courts saying that you didn't want to sign this. Judge will say, okay. Judge is going to issue a warrant for your arrest. Once that warrant is issued for your arrest, you can check CCAP and see that there's a warrant issued for your arrest. Your attorney will let you know that the warrant's issued for your arrest. Then you can turn yourself in. But right now, we have no legal rights to hold you. Because you're saying that you didn't sign it.
That's cool. You have the same thing. So my question is, essentially, I had like a slander campaign run against me for a warrant that didn't actually exist like a week ago. And so like, I'm really, like, I don't want there to be like a warrant issued based on like, I don't want it to look like I'm neglecting my duties. Obviously, like I'm coming here, like I'm prepared to sit for this instead of signing that piece of paper. Like that's fine with me.
And then we'll go to court for this on the 2nd.
As long as, can we get it on record like we're like here on the 27th, like trying to deal with this, and like, well, we have to go to the courts to do it, and that's cool. I just
beat the dead horse. Right?
All right, hey, but if you don't beat the dead horse, sometimes they like to pretend like there's something going on there, and I just don't want none of that. So
nobody's trying to trick you.
Also, for the record, can we state that I'm a model inmate?
No,
I'm fabulous.
Is there ever such thing?
He wasn't a model?
Yes.
All your inmates for this, so I guess I'll see you easier.
Right? You guys wouldn't have to do anything if I was arguing. So, party at mi casa?
Yeah. We're free still.
We're free. We're wearing fresh boxers. What's up? Hey, Daniel. Come get it on the art.